My name is Bob Allen, and I am the professor in this course. Please be sure to read all of the information provided in the course for Module 1. This video is intended to provide a little more information about some of the aspects of the information in Module 1. First, the Constitution of the United States is the supreme law of the United States. That means that the Constitution is the primary source of law in the United States, and that every other law that comes from another source must be compatible with the Constitution. That is, it must not conflict with what the Constitution provides. The Constitution does several important things. First, it establishes the structure of government of the United States by creating the three branches of the federal government: the legislative branch, which makes laws, the executive branch, which enforces laws, and the judicial branch, which interprets and applies laws. Each of those branches of the federal government is given certain exclusive powers by the Constitution, that is, powers that cannot be exercised by any of the other branches of government. The granting of exclusive powers to each of the branches of the federal government is called the separation of powers. And the fact that each branch of government has some power to override things that another branch of government does is called the checks and balances. The various provisions of the Constitution and the Bill of Rights, which is the first 10 amendments that were made to the Constitution, generally apply to businesses to the same extent that they apply to individuals. But there is one provision of the Constitution that has special application to businesses. That's the Commerce Clause. In Article 1, Section 8, Clause 3 of the Constitution, the Commerce Clause says that Congress has the power to regulate commerce among foreign nations and among the several states and with Indian tribes. That is, the legislative branch of the federal government has exclusive power to regulate interstate trade. Originally, that phrase, interstate trade, was interpreted to mean any trade that happened between people or businesses in different states was subject to regulation by Congress. Over the years, the interpretation of that phrase, interstate commerce, has been expanded so that Congress has the power to regulate any activity that is trade between people and businesses in different states, plus any activity that may have an impact on interstate trade. There are two parallel court systems in the United States: the federal court system and a separate state court system in each state. Who is involved and the subject matter of a lawsuit determines which court system will decide the legal dispute that's involved in a lawsuit. Each court system includes a variety of courts, beginning with the trial courts of limited jurisdiction, the trial courts of general jurisdiction, an intermediate appellate court, and an appeals court of final authority. Jurisdiction refers to the legal authority of a court to decide a specific legal dispute. So a court of limited jurisdiction only has certain specific kinds of cases, certain cases involving specific subject matter that it can be involved in. And the word appeals or appellate court refers to a court that doesn't try cases, but that reviews cases that have already been tried to make sure that the procedure used in those cases and the facts applied in those cases were proper. In the federal court system, the trial court of limited jurisdiction includes, for instance, the United States Bankruptcy Court, which only handles cases that arise under the federal bankruptcy law, and the United States Court of Claims, which handles only claims made against the United States government. The federal trial courts of general jurisdiction are called the United States District Courts, and every state has at least one of those. And the federal intermediate courts of appeal are called the United States Courts of Appeal. Cases that are tried in a United States District Court, a court of general jurisdiction, can be appealed to a United States Court of Appeals for review of the procedure followed and the law applied in the case. The court of final authority in the federal court system is the United States Supreme Court, which is the only court that is specifically mentioned in the United States Constitution, although Congress is the legislative branch of government, is given the authority to create other federal courts that it deems are necessary, and it's done that. In all except the federal courts of limited jurisdiction, judges are appointed by the president and approved by the Senate and are given lifetime terms. That is, they can serve in those positions for as long as they want to, and it's until they die or retire. And the only reason that they could be removed, a federal judge could be removed, is if they have committed a crime or they just totally ignore all of their responsibilities in that position. Federal courts have two categories of jurisdiction, two kinds of cases that they can properly consider. Those cases that arise under federal law and cases that involve people or organizations that are from different states. That's called diversity of jurisdiction. And in a diversity of jurisdiction case, the amount involved in the case has to be at least $75,000. If a case arises under the law of a state, in most situations, the state whose laws are involved in the case has jurisdiction to resolve the case. But there are a few situations when a state court and a federal court both might have jurisdiction to consider the case. That's called concurrent jurisdiction. And a decision in those cases has to be made which court, a federal court or a state court, will resolve the legal issues in the case. If there are any questions about any of the material I just mentioned or otherwise in this module, please don't hesitate to send me an email and I'll do my best to provide further information.